all rise and like, subscribe, and bang the gavel, baby. And good morning. Click, 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 click. Creed's not here, but I am. We're going to check out a little bit of Zoom court. I believe we're in Michigan. These are people that were arrested yesterday and going before the judge for the first time here on the weekend. Hope everybody's having a great weekend, by the way.
Appointing authority as a public defender. They'll make a determination as to whether or not they'll represent you, but they are here for the purpose of arraignment, of course, this morning.
Yes, sir.
Mr. Dewey, the people want to respond?
Yes, Your Honor. We have no objections to a PR bond. We just has a condition of no contact with co-defendant Anthony Selma. This was a case involving both individuals in a vehicle with two fully loaded handguns. Neither had CPLs. There was open intox
Not good.
in the vehicle, so we'd ask for standard drug and alcohol testing.
Yep, thank you.
Don't know how many cases they're going to see this morning.
Thank you, Your Honor. Lindsay Abramson with and on behalf of Mr. Smith. At least for the purposes of arraignment today, our office will be withdrawing on either this case or Mr.
Good to
Selma's.
see everybody.
Once we take a further look at the conflict. Your Honor, we are asking for a personal bond. He's a self-employed barber.
Hello,
he has a second
Grato.
job as well. He's born in Michigan. He's lived in the area.
Hope you're
for
feeling better.
years. And he's also full-time dad. His kids do live with him. He is fine with any conditions the court sets. Thank you, Your Honor.
Thank you. Ms. Abrams, just on your court-appointed request, you had his first name misspelled, just for your record.
Did I write Zoo?
Oh, thank
my
you, Your
God. Are
Honor.
you kidding?
Thank you for catching that.
okay.
I apologize.
That's no problem. All right. Mr. Smith, are you on probation or parole right now?
No, sir.
Any other court cases going on right now?
No, sir. This is my first time in so long.
Okay.
It's been for a hot
Alright.
day. Mikey Hatt, good to see you, buddy.
Condition of bond is you're not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card?
Yes, I do.
You do. How long have you had that?
Morning, Robbie Rob.
Going on
Our guy.
a year. I renewed it. So it'll be expiring in April, actually.
Okay. All right. Your intention to renew it?
If you would, still,
I mean,
I know
I
it's
don't
the
care.
weekend, but please like
I
this
don't
video.
care to smoke anyway.
Okay. All right. Well, if it's not medically necessary, you're not utilizing currently for medical purposes, then we'll just go ahead with a blanket non-use of marijuana, including drugs, alcohol, marijuana. Okay.
Judge, I don't like it. I just
You
do
own
it
any
because I was with my
any other
friends.
firearms other than the one that was involved in this incident?
Good.
Yes, I have a 9mm Draco.
Okay. That's registered to you?
Yes,
It's
sir.
good.
All right.
It's real good.
Yes,
Mr.
I
Dowie,
have it already.
do people have any opinion on the other firearm he owns?
No, I don't have any more.
I was asking the prosecutor, sorry.
Oh, okay.
Mr. DeWeed, you're muted.
I'd ask that that you be surrendered to the police until this case is resolved.
Dewey.
Okay. All right.
Mr. DeWeed.
Okay. So you're not to possess or purchase a firearm, ammunition, or other dangerous weapons. So the other firearm that you do have, you need to be held by the sheriff's department until such time as this matter is resolved. And you're not to acquire any additional firearms during the pendency of this matter. Do you understand that?
No pew
Yeah,
pews,
so would you
my
want me to
friend.
bring it here?
I'll get to
Or-
that in just a second.
Okay.
They don't really like surprises, so we'll sort that. We'll sort out a method to get that taken care of.
This judge has been pretty nice to
Alright.
people, by the way.
You're not to violate any criminal laws. Of course, you will need to appear to all court hearings and other places as directed by the court. Court's further ordering you not have contact with the co-defendant in this matter.
He gave him the
Against
chance,
Selma,
Pike, to
there's
say he
absolutely
was
no
going to use it.
contact or indirect contact with family or friends, no text message, emails, social network posting, or any contact of any sort whatsoever. Do you understand that?
Yes, sir.
Okay. All right. Mr. DeWeed, anything further on conditions here?
No, Your Honor.
Oh, really subject to random drug and alcohol testing to verify you're not using drugs or alcohol. All right. Ms. Abramson?
This is either Michigan. I think
Thank
it's
you, Your
Michigan.
Honor. We are asking that Mr. Smith be released on a personal bond. I'm sorry, Your Honor. I have no additions to what the court said.
Okay, thank you.
So you go see
Mr.
Terminator.
Smith, said
So
that
you go
other
see.
firearm was a 9mm. What was the make of it?
Draco.
Draco?
Yeah.
Does anybody have access to that right now?
Draco.
Oh no, it's at my house. I live over on McKean, where that's my firearm at. But I be over in Lakeview, so I don't even be near it anyway.
Well, we just don't want it out and about regardless, so.
No, I don't even touch it. It's never
Yeah.
even left my house ever.
He doesn't
Okay.
touch the weed, but he was with the weed. He doesn't touch pew-pews, but he was with the pew-pews. This guy has a lot of things he doesn't do.
Mr. Dawid, would a civil standby be appropriate to collect that?
Crystal with the
additional
save.
firearm?
That's what I thought, Michigan.
Can you say one more time?
I was talking to the prosecutor. You're muted, Mr. Dawid.
I have no objection to a civil standby.
Okay. All right, so
The
Mr.
wretched
Smith, how we're gonna
wretch.
address that, the other firearms, you'll need to contact the sheriff's department when you get out of jail, tell them you have a civil standby for the purpose of collecting that firearm. They'll make arrangements to go over where they're with you for the purpose of them collecting that firearm. So you're not to go to that address until that firearm has been collected from that
No
location.
problem at all.
They'll
Yes,
take
sir.
care of that as soon as you get out of jail, okay?
Yes, sir. No problem.
All
at
right.
all.
Facebook.
Next court date will be probable cause conference on March
Good to see you
29
on
at 9
Facebook.
a.m. That'll take place via Zoom. Are you familiar with Zoom?
Yes, sir.
If it doesn't resolve at that hearing, it'll proceed to a plenary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that is probable cause crime was committed, probable cause you did commit the crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred to circuit court for trial. Do you understand that?
Yes, sir. I do.
That hearing will take place on.
Am I the only one that thinks
May
Lindsay
5th,
has
also
a very
at 9 a.m.,
opulent
also via
home?
Zoom.
I mean, look at her house.
$5,000 personal recognizance bond, mean you're free to go today. However, should you fail to appear for court, fail to drug test, fail to
How much are they paying
turn that
her?
firearm over, or fail to appear for a court date, a warrant would issue for your arrest, and your bond would start at $5,000.
Good to
depending on
see
what
you.
happens
Let's
to
go.
There, of course, that would be the minimum for it. Okay.
Yes, sir.
All right, Mr. Dewey, anything further on this matter?
No, Your Honor.
All right, Ms. Abrams, you all set?
Yep, all set. Thank you.
All right, Mr. Smith, you're all set for today. As soon as possible, make arrangements for that civil standby. Okay.
I'm gonna do it as soon as I leave out.
All right, sounds good. Have a good day. Stay safe.
You too. Thank you, guys.
Knock on the door. Typically, they knock on the door when they're done like. Are you talking about the We Got a Case channel? We have a Chase exclusive channel called We Got a Case, which is just getting off the ground. Fred Franklin,
Your name, sir?
the governor's here.
Your name, please?
Anthony Selma.
Just a moment, sir. Okay.
Yeah.
What about my guy down here in the bottom that's blacked out at the moment? We're going to get to him. He's just sitting there. I think she might live in a library. It's very, like I said, it's very opulent home. She's showing up here, throwing her paper around. Big monies, no whammies. Hopefully everybody's having a great Saturday. I saw we had
You'll
some
say Mr. Anthony Selma, 22F1000443. Allegations on March 18, 2022, Superior Township, Washington County, State of Michigan, at Clark at or near Ford. You did carry a dangerous weapon identified as a pistol, whether concealed or otherwise, in a vehicle operated or occupied by yourself. A felony carrying a maximum value, if convicted of up to 5 years in prison, a $2,500 fine, or both. You understand that?
Yeah.
Count 2, you did possess and or transport and or carry a firearm when ineligible to do so because you've been convicted of carrying a concealed weapon. Let's say felony carrying a maximum value, convicted of up to 5 years.
What are you
in prison,
doing here?
$5,000 fine, or both.
I got a couple of minutes, so Mom Pa get here.
Trying to advise you certain rights. You have the right
Hey,
to
this
remain
is
silent,
live on a
and the right to
Saturday
stand
court.
and use against
Yeah.
the trial. You understand
This is
that?
the second one. I let the first one
You also
go
have the right to
by,
be represented by an
that was
attorney
in
all
the
stages of these proceedings,
east
including before,
time
during,
zone,
and after trial,
and I
and
didn't
at
jump
any time you're
on.
being
And
questioned
then
by
this one
police
started
officers.
up about
If you're unable to afford
30
an
minutes
attorney, one
ago.
will
I said,
represent
well,
you at
let's
public
do it.
expense.
Why
You
not?
understand that?
Yeah.
Whatever you stand mute to the charge.
I don't know what to
and
say
you're not
about where
guilty of
Lindsay's
both
at.
counts.
Anyways, I'll shut up.
And
Sorry.
reviewing
We got a
contact
case. So
information
don't
for you.
want
We
anybody
have you on West Hills
talk
in
too
Inkster,
much.
is that right?
too much.
Yeah.
And your telephone ends in 2483, is that right?
Yeah.
And you have a Gmail address. The last bit of it is GIE@gmail. Is that right?
Yeah.
That information we
Kind of
passed on
took him
to
as an
the
AOL guy like me, but
appointed authority for public defender. They'll be in touch with you with regard to the public defender representing you. But they are here, of course, to represent you for the purpose of arraignment this morning. The people on address bond, Mr. Weed?
Yes, Your Honor, thank you. Again, we have no objection to PR bond. He has no, wish no contact with his co-defendant,
glad.
Mr. DeAndre Smith, who you just arraigned. But I do see in my notes that the defendant is an absconder on probation out of Wayne
Ooh,
County, so I do
not
not
an
know if he has a
absconder.
hold. Maybe Lindsay can tell
Facebook
us.
needs more court.
Yes, it does.
And he is a felon, so we'd ask that he has no weapons and that all weapons will be turned over and the standard alcohol and drug.
And these are all things that happened just
Thank you,
yesterday.
Your Honor.
Oh,
no kidding?
With me,
Yeah.
we have Mr. Selma, Assistant Public Defender. In regards to bond, I did not see any holds on him. So I don't have an answer as to that. But we do agree with a personal bond on this case. He lives here locally. He is a cab driver. He's lived here his whole life. He does live in Wayne County.
Cab
Mhm.
drive.
He has 4 kids, all under the age of 18.
He's got a 4-star rating out of
that
5.
he can get out and work to support them. And he will comply with any conditions that the court sets. Thank you.
Yeah, that one's about the end. That courtroom,
Selma, you're on
that
probation
room was
parole
full
right now?
earlier.
No.
I was just pulling it up to show you that there is more than one court going on right now on a Saturday. So
That every
Do we get any
bench
further
was
on the
full.
information you had
I
there?
mean, everyone.
No,
It was
no, he
standing
just
room
said,
in there.
his
Wow.
notes just said that he was absconding from probation out of Wayne County. That might be an old probation that he's been discharged from. He has a prior felony. So it might be outdated information.
He
Thank you.
could be. He's handsome as hell.
Mr. Selma, bond conditions are that you're not to use or possess alcohol, illegal drugs, or marijuana. You are not to leave the state of Michigan without permission of the court. You are not to possess or purchase a firearm, ammunition, or other dangerous weapon.
Yeah.
Meaning you're not to acquire any additional weapons.
This
Presumably
is
the
good.
weapon
That'll
that's involved in
do.
this matter has been held by the
Good
sheriff's
damn good you
department, and
Sounds really good.
I'm in a little bit of a tricky spot because I can't ask you if you have any other firearms. We can't let you admit to a crime. So
Anything on a Friday, I guess.
if you do have any other
Mhm.
firearms, you need to get rid of them. I guess there's
A
no
lot
better way to do
of
it.
choking people,
Turn
hitting
'em over to the
people,
sheriff's department.
getting pulled over
You're
with
not
guns and
violating criminal
weed.
laws. Of course, you need to appear for all court hearings and other places as directed by the court. Do you have any questions with regard to these conditions?
No.
Mr. DeWeed, anything on the conditions?
No, Your Honor.
Ms. Abramson?
No, Your Honor.
Okay. Next court date will be and you're not to have contact with DeAndre Smith. I apologize. That's really one of the more important ones. This means absolutely no contact, no indirect contact with family or friends, no text messages, no emails, social network posting, telephone contact.
I
or
think
any
that was the guy that
contact
was
of any
just
sort
in there
whatsoever.
before him.
Verify
Oh,
you're not
really?
using drugs, alcohol, or marijuana.
Yeah.
You'd be subject to random.
More
drug
than
and
who's?
alcohol testing.
They were together.
Next court date will be a probable cause conference on March 29th at 9 a.m. The matter not resolved at that hearing will proceed to a plenary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that probable cause crime is committed, probable cause you committed a crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred to circuit court. That matter would take place on April the 5th, also at 9 a.m., also via Zoom. Do you understand that?
Yeah.
Why did I never think
Given that the
a magistrate was a
defendant
judge?
I'm sorry.
I don't know.
Somebody said something. Okay.
No,
Given
sorry.
the defendant was
Yeah.
is, charged with possession of a firearm and was
Maybe
ineligible
because
to
those
serve time
times
in
that you went
possession, the
to
court does find
bail
there is
out,
a risk to public safety given the nature of the
people at the
activities.
magistrate, you know what I mean? Like you just walk
Yeah.
up to
For that
you
reason,
walk
cash
up to a
bond is
little thing and
appropriate
you
for public
Yeah,
safety.
like a little
Of
booth.
course,
keep the
saying
money
cash
inside.
bond, not
That's probably why.
$10,000,
I get
goes
that.
either in cash or corporate charity, substitute is placed on the record. All right, Mr. Selma, you're all set. Stay safe.
I mean, if you want to get married quickie, you go to the magistrate.
I press the bond for both counts or
No, the $10,000 cash corporate charity bond. You have to post it either in cash or through a bail bondsman.
so I gotta pay 10% of that if I use a bail bondsman or is cash,
Let's-
you said cash surety?
Cash or surety. Contact the bail bondsman, they'll tell you how much it costs to them.
All right.
All right, if you post the bond, you need to be up to community corrections within 24 hours to drug test.
Ooh,
All right.
All right, you're all set, sir. Stay safe.
a lot of drug testing mandatory with this stuff. think a storm just broke out here.
Looks like it.
We keep ignoring the guy in the very
Bransford, is
darkly
that you down there?
shadowed room.
You're muted, sir. You can either unmute it or have the corrections officer unmute for you. There you go. All right, thank you. Good morning.
Good morning.
I just sent you a link if you need
Bill,
it.
State of Michigan versus Demond Bransford.
starts at
Case
like
numbers
47 minutes.
F20289,
With Meg.
298, and
Hmm.
22F55549. The first case alleged that on April 14, 2021, Ypsilanti City, County of Washtenaw, State of Michigan, at 501 East Michigan Avenue, you did buy, receive, possess, conceal, or aid in concealment of a Ford Edge, a stolen motor vehicle that you knew or had reason to know had
Not
been
a Ford
stolen,
Edge.
embezzled, or converted. That is a felony carrying a maximum penalty if convicted of that charge of up to 5 years in prison, a $10,000 fine, or both. You understand that?
Yes, sir.
Count 2, you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance
does.
cocaine, a felony carrying a maximum penalty if convicted of up to 4 years in prison, a $25,000 fine, or both. You understand that?
Yes, sir.
Moving on to 22F55549, the allegation here is that between the dates of March 1st and March 6th, 2022, City of Ann
Fishing
Arbor,
after
County of
hours.
Washtenaw, State of Michigan at 1120 South Maple, you did intentionally discharge a firearm in a facility that you knew or had reason to believe was a dwelling or potentially occupied
I s-
structure. In
I see
reckless
this is
disregard
some
of the safety of another.
pretty big
Felony
charges
carrying
for
a
these
maximum
people.
penalty of
we're
up to
seeing.
10 years in prison, a
Yeah, they're all over the
$10,000
place.
fine, or both. You understand that?
Yes, sir.
Count 2, you did possess and or use and or carry a firearm and ineligible to do so, having been previously convicted of concealed weapons felony. That carries a maximum penalty if convicted of up to 5 years in prison, a $5,000 fine, or both. You understand that?
Yes, sir.
Of
Count
course he
3,
does.
you did possess and or use ammunition when ineligible to do so because you've been previously convicted of a concealed weapons felony. That's a felony carrying a maximum penalty if convicted of up to 5 years in prison, a $5,000 fine, or both. You understand that?
Yes, sir.
And count 4, you did commit the crime of obstruction by justice, by obstruction of justice by threatening a witness or
Or
speaking
by
with
justice,
police
your choice.
as a felony carrying a maximum penalty of up to 5 years in prison, a $10,000 fine, or both. You understand that?
Yes, sir.
These are felony counts, therefore the court does need to advise you certain rights. You have the right to remain silent, and you say on the record can and would be used against you at trial. Do you understand that?
Yes, sir.
You also have the right to be represented by an attorney at all stages of these proceedings. This includes before, during, and after trial, and at any time. you're being
It's interesting.
questioned by
Do they
police
set different
officer. Your
bond?
Honorable
You
Court
think
Attorney one will represent you at
Oh, yeah.
expense. Do you understand that?
if there's no bail bonds, do they set like $100 bonds? You know, for like if we're $1,000.
You would think, or everybody's just filling up the jailhouse,
Yes, sir.
Yeah.
stacking them like firewood in there.
Yes, sir.
You currently do not have an email address?
You got to see your wine cellar, TK.
Okay. That information will be passed on to the appointing authority for public defender. They'll reach out to you with regard to them representing you for the remainder of this case. They are, of course, here for the purpose of arraignment this morning. All right. Mr. DeWeed, did the people want to address bond for Mr. Bransford?
$16.
You're muted, Mr. DeWeed.
I'm sorry, yes, Your Honor. With respect to case 22F55549, we are asking for 100,000 cash surety, 100,000 surety bond. If he was to be released,
Not
we have
getting
no
out this
contact with Dwight
weekend.
Miller, Alfornia Webster, Victor Stevens, and Alonzo Reddick, and a no-go to 1120 South Maple Road in Ann Arbor, all standard bond conditions. After the incident, defendant returned to the scene and threatened Gregory Jones, resident of apartment 309, because he
Thank
believed
you,
Jones
Mikey.
had
I'll check
snitched
it
on him.
out.
I think this is an
Mikey
escalating
Hack,
situation.
Attorney at law.
Thank you.
Appreciate you,
Sorry,
buddy.
Mr. DeWeed, can you repeat the no contact name, please?
Doing the Lord's work, as they say.
Sure. It's Alonzo
Sure.
Reddick, Reddic,
By the way, Mikey Hack on Twitter is
Dwight Miller,
Mikey Mike.
Alfornia.
Ought to be
Webster,
Michael Mikey Mike.
ORNIA.
This is
and
Michigan,
Victor Stevens with a V.
where they zoom and
We'll pass it
YouTube
around.
everything.
California's last name? California's last name?
$100,000
Webster.
bond requested. Cash.
And Stephen,
Victor Stevens.
Victor Stevens, thank you.
What's your vector?
Do you
Vic?
need the address?
Vitty Vector Victon Stevens.
That was the alleged location, correct?
His
Yeah.
friends call him Rick.
I've
He's
got
already
that.
been trespassed the bond match, but we just want to make that as part of his bond.
Okay. All right. Okay, Ms. Abramson?
Thank
So
you,
they
Your
do
Honor.
adjust it
An assistant
about the
public
fact that
defender
there's
with
no.
and On behalf of Mr. Bransford in both cases,
Sorry.
Your Honor, we are asking that the court impose a low reasonable cash bond in these cases. We understand the serious nature of these charges. However, they are not proven.
What you
at
calling
this point, as the
reasonable?
Court is aware by the state.
1,000.
So we believe 100,000 is excessive and are asking for low cash bonds. Mr. Bransford is from the area. He's lived in Michigan his whole
Here we
life.
go.
He does have
Mhm.
community ties. His mom, his
Single
brother,
mom.
his sister are all here.
He won a fifth grade
and
spelling
he
bee.
currently has a job at McDonald's.
Yeah,
we're asking for a
baby.
lower bond than
100,000, no
the state
problem.
knows.
Then I
Thank
saw
you.
what they're paying people these days.
Lindsay,
up
can
there.
you
Any
ask-
charges warrants
Can you
the
ask
hold
him when
order?
that steak
Not that I
damn
am aware of,
bagel's
Your
coming
Honor.
back, please, in the South?
And how long has Mr. Bransford been in custody?
I think since yesterday,
Okay. And where and how was he arrested?
walking down the street.
Okay.
Your Honor, this is,
All of
I just want to say, this is a situation where he randomly fired
Mm.
inside of an apartment with these individuals, three people individual
Mhm.
in there where they had to duck to avoid being shot.
Okay, thank you.
Pee-pewed, you mean?
Mr.
Sorry.
Bransford, you hear me okay?
Yes, sir.
Here it
Okay,
comes,
court's
bud.
gonna set bond condition in this matter. You're not to use or possess alcohol, illegal drugs, or marijuana.
50.
You are not to possess or purchase a firearm,
50K.
ammunition, or other dangerous weapon.
I say
You are
goes
not to
with the
live in the state of
100.
Michigan without permission of the court. You are not to commit any assaultive, terrorizing, frightening, intimidating, threatening, harassing, molesting, or stalking behavior towards any individual. You're not to have contact with Gregory Jones, Alonzo Reddick, Dwight Miller, Alfornia Webster, or Victor Stevens. It means absolutely no contact, no indirect contact with your family or friends, no text message, email, social network postings, telephone contact, or any contact of any sort whatsoever. This condition applies whether you're in the jail or not in jail. Do you understand that?
Yes, sir.
You're not to violate any criminal laws, and of course, you need to appear to all court hearings and to other places as directed by the court. You're also not to go to the address of 1120 South Maple Road. Court will order a GPS tether with that as a restriction zone.
Can you believe it?
These
Go to work
conditions will be
every
placed in
day
the
at
law enforcement
McDonald's.
Information network, meaning should you come into contact with the police, they will have access to that information. Should they witness or suspect a bond violation have occurred, you would be arrested for that bond violation. Do you understand that?
Yes, sir.
Okay. Mr. DeWitt, do people have anything further with regard to these conditions?
And nothing further, Your Honor.
Ms. Abramson, anything further on conditions?
No, Your Honor.
All right. Mr. Bransford, your next court date will be a.
So he's stuck with the 100K?
Probable cause conference on March 29th at 9
Mhm.
a.m. If the matter is not
Okay,
resolved
just-
at that hearing, it will proceed to a preliminary examination. That is a hearing point in time. The prosecutor must present sufficient evidence and or testimony that probable cause crime was committed.
Answer
probable
this
cause
some
was
bitchin'
committed
phone.
crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred.
He's about to
circuit
drop the
court
hammer.
for Trial. Do you understand that?
Yes, sir.
That will take place on April the 5th, also at 9 a.m., also via Zoom. All right. As to case number
Thank you,
F2,
Chuck.
22F20298, court is going to set a 5,010% bond to assure parents' court dates.
Well, he won that.
As to 22.
Good job, Lindsay.
5549.
Got more charges.
Given the nature of the allegations,
Wait.
given
We have to do math.
grave concerns with regard to public safety and the danger already posed to the public based upon the alleged actions of the defendant, the court is going to set a cash bond to assure public safety. That bond is set in the amount of $125,000 to be posted either in cash or corporate surety, subject to conditions placed on the record.
Did he go up
All right, Mr.
25K?
Bransford, you're all set.
Wow.
Have a good day. Stay safe.
If he got 125 on the one and 5,000 on the decree, if my Mikey math is correct, that's $130,000 to get out.
I didn't see that coming.
Son
They
of
just
a
cut it?
Bitch.
Yeah, they did. That was it. He was the last one.
Woo. All right, so I got this clip you
Damn.
sent me. Do you want to set it up for me? What's going on? here?
It's another Meg case. I'm not 100% sure, to be honest with you, and Mom and Pa are gonna be here in a minute, but yeah, just start rolling it. And I watched it. I think that Vicky sent over that just after it happened, and I'm pretty sure I've seen it. But listen, anything with Meg, if you guys haven't seen Meg yet, I must say She is the best.
So
Turning
you're
money
ahead
can
of the
buy.
game, although it doesn't sound like it's gonna pay every penny of it. Today is March the 4th.
Oh, Christina Bright's here.
I'm gonna continue this until April the 4th.
Whispering Pine sounds like a beautiful place to
at
stay.
1:50.
Whispering Pines is trying to get people out every day.
Whispering Pines Apartments, I'm guessing.
I think I've ever looked it up.
Man, they
If all of this
slapped them.
rent is paid,
That's
there would
crazy.
be a dismissal,
big.
so nobody would need to appear. So it's important, A, that you stay in contact with their manager, and 2, you stay in contact with
Comes
Keystone.
up in the next case.
You're ahead of the game. You've been in contact with Keystone. You've got 6 months worth of rent, 7 months worth of rent. That's
See,
quite a
Andrew, his
benefit,
Rogness is here.
but it would get
his
your rent
Rogness.
paid through June and have you situated to continue on from there by yourself. So, Mr. Weiss, it looks like
Hey, pause that real quick and we'll check out Whispering Pines real quick because we hear about it all the time. Mobile Home Park, Whispering Pines 2, by the way.
Anytime you hear a second one, that means the first one did so well. We wanted to bust out a. Okay, yeah,
They offer some
catching
pitching.
and snake catching.
Oh, is that it? That's the only ones that are uploaded to Whispering Pines. Seriously? Come on now.
I mean, the one of the kid.
Yeah, I mean that's a great
Is-
picture. I mean, I
It
want to live
says
there
it
now.
all. It's Whispering Pines Green.
Is there any reviews of the place? You think?
Review bra, come in and lay it down on this.
Let's see. Well, there's
Questions
5
and
questions. Oh,
answers.
3.2 out of 89 reviews. That's not bad. I mean,
Oh, there's a lot of ones. Yes, there is a
Oh,
lot.
look
I was about to say a lot of ones. Bigger D. Here?
Bigger D, going by the court system, 3rd district, there's constant fighting and arguing going on here. I definitely would not move here.
So Zoom Court's done no favors for Whispering Pines.
Yeah.
Duh.
Full of field workers who drink and party all night. The management does not care about the conditions of the buildings, just the money they can make.
Kind of like Creed and Mikey. They don't care about nothing but the money, baby.
Yeah, nothing but the money. They just talk. Horrible
Paper
place
chasing.
to live. Lived there with my girlfriend at the time. Can't eat, win. Get a hold of the owners. God, that's too funny.
One person said great place to live and still only gave it 3 stars.
Yes. Stop, Colty. That's funny. Not enough supervision. People subletting and basically not caring for the property. It's kind of nice.
They
a
let
lot of work.
anybody fish here. See photo enclosed.
Yes. That's funny. That's funny. Anyway, so that's Whispering Pines 2. Back to court.
gonna resolve itself.
It appears so, yes.
I'll give you some advice. Close your closet door when you zoom in and look at a complete view of your wardrobe there from behind. But
Roasted.
all right, I'll continue this to April 4th. I expect there'll be a
There's Mon
dismissal.
Pa. I'm out of here. See you
before that
guys. Enjoy
time.
court. This
If
is a
there
good
isn't,
case
we'll
when
deal
Meg
with it
comes
on the
out.
record
Oh, good. We're going to
at
watch it.
that
I think
time.
you'll enjoy it.
Ms.
Have a
Woods,
great
do you have
weekend,
any
guys. Oh, we'll
3
see you at
o'clock.
3 o'clock. That's right.
All right, you're both free to go.
Thank you.
Thank you.
Thank you.
Thank
Come
you.
again.
Thank
Bye.
you, guys. That's very nice of you, guys.
What a farewell for this guy.
Hey, I'm not out. Oh,
Calm down.
Hopefully that doesn't show up on the internet.
Yeah, that happened.
Christina heard that.
Nice. Nice woo on the way out.
All right, well,
That
I'd
was
be
great.
happy too if somebody paid 7 months of my rent.
No shit.
Yeah,
me too.
All right, Miss Bauer has joined us.
Woo, we
Miss
suckered
Bright.
those guys.
I want to make sure
Oh,
you can
Meg.
hear me. You seem to hear what just happened there. Do you have headphones or anything you could use with your?
No, the
computer?
headphones don't really help me. I have to pretty much be the lip, to be honest.
All right. Well, you heard that lady give that hoop and holler, so I thought you heard that. Can you understand what I'm saying?
Yeah, because I'm reading your lips.
All right, I will try to speak slowly. If you can't hear me or understand, raise your hand, okay?
Okay, okay.
Don't
All
come in my
right.
courtroom with open
This
doors.
is a bit complicated.
Meg, get your manly shirt straight, please.
Good afternoon, Ms. Bauer.
Good afternoon, Your Honor.
Oh, hell.
This is file 212042. Jose Lopez Garcia versus Christina Bright. Mr. Andrew Rognus is here for the plaintiff.
His
Ms.
Rognus.
Meg Bauer of Legal Aid is here for Christina Bright, and Ms. Bright is here. This
This ought to
was
be good.
filed as a termination of tenancy action. The case was actually filed back in December. The
Quite some time
landlord
ago.
wanted Miss Bright to move, indicated the lease had expired in 2017. We had a hearing on January 28th, and Mr. Rognus was here. The defendant, Miss Bright, did not come on
It's a
January
blanket
28th.
comment for everybody, including myself.
So we made a record. Mr. Rognus indicated the defendant had not paid in 5 months or
We're gonna do voyeur
thereabout,
at 3.
had not paid any rent.
Voyeur voyage.
And
3
they
o'clock.
asked for a default, but I was unwilling to do one at that time. So I continued the matter until February the 7th. We were here on February 7th, and Miss Bright did show up on that day. Mr. Rognus still asked for a termination of tenancy,
Get it.
asking for the premises back. The matter had already been adjourned once for 10 days or so. And so I granted Mr. Rognus's motion for entry of a judgment. I indicated that Miss Bright could discuss that with legal aid and they could request a stay, which is a stop the proceedings. Ms. Bauer did file an appearance on behalf of the defendant and did request a stay. She filed a motion
Hey, Eric.
for relief from judgment and a stay. I did grant the stay, but
Thank you.
not the other part. So Mr. Rognus filed a responsive brief, and I set the matter for hearing today. Ms. Bright, are you still in the premises there? Are you still living there?
Yeah,
All right. Mr. Rognus and Ms. Bauer have been discussing the matter.
Or the
and
wall's
I
still
understand
orange.
Perhaps there's been some settlement.
Yes, Your Honor, if you want me to
All right, now-
recount that.
Yes, but make sure you speak so she can read your lips.
Okay. We have agreed in order to protect Ms. Bright's ability to get subsidized housing in the future to set aside the judgment in this case.
They're doing her a favor. Gotcha.
To do a conditional dismissal specifying she will be out by the end of May or June 1st. And if she's not out by June 1st, writ would automatically enter, no necessity for a hearing. And I did speak with Ms. Lucas from Keystone about getting October, November, December, January, February, and March rent paid current, and then on into the future. And Ms. Lucas indicated that there was some paperwork my client would have to do. I gave her my email address so that she could forward that to me and I could forward that to my client.
How can we all get on some of this stuff where they're going to pay your rent all those damn months? That's crazy. And they're going to do this lady the favor of not evicting her, is what it boils down to, because then it will allow her in the future to be able to get other subsidized housing and be able to rent somewhere else once she's removed herself from here. So if you're just catching up, that's what we're doing. Read my lips.
Ms. Bauer, what's your position regarding that?
That is an accurate recitation of the agreement. I too spoke with Keystone Place. I spoke with both Ms. Lucas and Ms. Gross to confirm that Ms. Bright would be able to go through the program on the basis of the terms that Mr. Rognes and I discussed. That is not to say that they guaranteed that Ms. Bright would qualify for their funding under the other requirements.
Damn,
But
Terminator.
that the terms that Mr. Rognes and I had discussed were not an automatic bar to Ms. Bright receiving assistance. And in light, go ahead, Mr. Rognes.
I was going to indicate that I discussed with Amy if we did need to file an amended complaint in order to allege non-payment. There actually has not been an answer filed, so we're within our 14 days, but Amy has not indicated to me that that would be required, at least not at this point in time. And I think Amy needed to talk to other people in her office.
I
Ms.
believe,
Bright, do you understand that this order would require that you move out by June 1st? Do you understand that?
Yes, I do, Honor.
And you intend to try to move by June 1st?
Yes, I am. I'm willing to move by
And-
June 1st.
And then you agree to cooperate with Keystone to see if they can pay your back rent?
Yes, I do.
All right, who's gonna do the order?
I can draft that order.
right.
We'd like to, we had discussed framing it as a conditional dismissal.
Yeah,
That's
just
fine.
make sure you put the set aside of the judgment in there too.
Yeah.
That way it'll clean up her history.
Yeah.
I won't forget that part.
All right, Ms. Bright, this gives you March, April, May to try to find another place to move to.
This is me after
Okay.
taking a
Also,
shower.
They get much of your rent paid. Hopefully.
That's
this
my
will
natural
work.
look
If
of
you don't
roughness.
move by June
Naturally
1st,
rough.
They can get a writ of eviction and force you to move. Do you understand?
Okay, I do have a question.
All right.
What happens if I move out way before May 1st, June 1st,
that's
and I get a
fine.
hold of the,
When you move out, you turn in the keys and give them your forwarding address.
okay, all right.
Now, I need to tell you something. I told you this last time, and I'm gonna tell you again. If you reach an agreement with the plaintiff, which you just did, you reached a consent agreement. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a further hearing. The judge would make a ruling. If the judge did not find in your favor, the original judgment would stand. So
Okay.
right now, you have until June 1st to move, or you are subject to being evicted.
Okay.
Okay,
Alright, yeah.
all right. Do you have any questions?
No, but thank you.
All right, you're free to go.
That reminds me of that old skit from Saturday Night Live when Garrett Morris was doing the translation for the people who had hearing issues. And he was yelling.
Oh, well, that's like Bob Kelly's interpretation here at the courthouse. All
Yeah,
right,
I remember that too.
just because you say it loud doesn't mean that people understood. All right, thank you, Mr. Agnes. Ms. Bauer, you're stuck with me for a bit longer here.
I don't know why
Get
Creed
that
wants
to
to
you.
watch this.
All right.
Okay, yeah, go ahead and email that to me and I'll forward it to Mr. Lopez Garcia. Thanks, Amy. Appreciate it.
Ms.
Thanks,
Lucas,
guys.
Amy, let me know if you, well, you're not going anywhere. Thank you, Andy.
Yep.
Yeah.
But let me know if you
Mr.
have issues.
I will.
Gibson is here to see me. Paul, what have you got for me?
I wasn't sure, don't we have, I thought Paul Rocca,
He is.
we're gonna do that soon or,
Yeah, we're gonna do it at 2:30.
okay, 2:30, okay. I'm just.
So,
I know, right? I
we
just
will
I didn't do anything too. I just walked out.
finish our one more
like
case.
this.
Now, we do have arrangements with Mr. Rocca to
Ooga,
zoom in
raka,
from the
ooga,
forensic
ooga,
center.
ooga, raka.
Okay.
Bush has appeared out of nowhere. Hello, Bush.
I think that's that one. No, I think I got one more lawyer. John, which case are you here on?
I'm here for Paul Rocco.
Oh, what time do we set that? At 2, isn't it? Yes.
That's
There they are.
MILF
So we're
Esquire.
going to stall our landlord-tenant case for one moment. Ms. Reed, my apologies. I have to take care of this, Ms. Bauer.
Uh-oh.
Judge,
I'm
would
gonna-
you be willing to put Ms. Reed and I into a breakout room?
Certainly, that's time you could use efficiently.
I'd love to talk with
and I'm
her
gonna-
in private.
Take up this matter.
All right. I don't know why
Becomes
Creed wanted me to watch
frustrating to be
this.
2 places at once. So Sarah, if you
I'm gonna s-
unmute your mic.
I'm gonna stop this and we're gonna jump to something else, okay? Everybody just give me one moment. We gonna make a jump like Panama. We gonna jump. There's that roughness he was talking about right there. Whew, he's right. Looking bad this morning, Mikey. Real bad. I can't believe I come in here and not camera ready. Last time I do that, guys. So we're going to jump over to Judge Porter from yesterday over in the beautiful F-Pod. Everybody knows all about F-Pod and what goes on over there. And these are all juvenile offenders, not defenders, but offenders. And we'll see what was going on yesterday. We did not see any of this. So
Court's order may subject you to civil and/or criminal contempt proceedings. These hearings are being offered to the participants by Zoom as a convenience. However, these are court proceedings and you're expected to behave as if you were actually physically in my courtroom. Interruptions will not be accepted or tolerated, and you will be subject to removal without further warning and ordered to appear in person for all future hearings. Unless you are an officer of the court, you're expected to have your camera turned on and your microphone muted until such time as the relevant case is called.
Was he a serial killer?
Also, all participants are expected to have their backgrounds free from distraction and not be in moving vehicles, etc. Again, please keep your cameras still. If you cannot abide by these basic rules, you will be removed without further warning.
They'll throw your ass
We have
out.
13 cases on the docket, 9 of which will be broadcast. First on our docket is DeCavion.
Where's the Cavion at?
Yes, sir.
Oh, there he
Cavion,
is.
my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and I have not seen your attorney, Brian Bolton, here this morning. So I'm going to ask Brian Newman, another attorney who regularly represents kids in our court, to step in on Mr. Bolton's behalf. DeCavion, you're here on an aggravated assault with a deadly weapon charge. The court has previously found that probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. You have a determinate sentence hearing in front of Judge Kim next week. You've been level 1-0 since the 12th, but as you probably know, on an aggravated gun charge, 6 days at level 1-0 is not enough yet to convince me that if I were to release you, you would not be a danger to the community. We take gun cases very seriously here, and those kinds of cases just take longer at level 1-0. Consistent demonstrated behavior of ability to follow the rules before we feel safe releasing you. And so I'm not going to authorize your release at this time. That will be the order of the court. Thank you, DeCavion.
Have a seat. Damn,
Alan.
Cavion Mama is out.
Good morning, George.
Good morning, Mrs. Weehey. How are you?
I'm good. How are you?
Okay. Are you Alan?
Yes, sir.
Alan, we know each other. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Uzoethi, is here. Alan, you've been level 1 outstanding for the last six and a half days. You're currently on probation, and you've got a hearing scheduled in front of, I believe, in front of me next week, maybe on Monday. Alan, normally I would be considering you for release right now, but because you're already on probation, it just takes a little bit longer than 6 days. Let's see how your hearing goes on Monday, okay?
Stay in
Okay.
here.
All
Bye.
right. Thank you, Mrs.
All
Uzoethi.
right, thank you, Anna. We'll see you on Monday, Judge.
All right. Thank you, Rita. Okay.
It's bad if we
Callie.
have to wait to see what
Yes.
another judge says when we consider letting you go.
Yes, sir.
F-Pod in the
Callie.
house.
Yes, sir.
Kelly, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And I thought I saw, I did not know, Mr. Houston could not be here today. I thought he was here earlier. So I'm going to ask Brian Newman, another attorney who regularly represents kids in our court, to step in for Mr. Houston. Kelly, I'll make this easy. The court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention. You're level 3 confined. I'm not going to consider you for release. I'm going to order that you continue to be detained. Thank you, young lady.
He is killing these, boy. Boom, boom, boom. We're only getting 9. That's 3 down, 6 to go.
Demarian. Are you Demarian?
What
Yes,
up,
sir.
Angie?
Demarian, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And your attorney, Brian Willett, is here. Good morning, Mr. Willett. How are you?
Morning, Judge.
All right, Demarian, the court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct. You've been level 1-0 for the last 7 days. However,
10
you're
business
here
days.
on 2 counts of aggravated robbery.
Thank you, Walter. I'm glad you like it. Oh, it's my stand there fanning themselves at the F-Pod. Send in the clowns.
Yeah, seven days to Marion at level 1-0. Not quite yet enough to convince me.
I don't think we're gonna let none of these guys out. Even though we just jumping through now.
Let's see. Mr. Morris, have you read the detention hearing report?
Yes, Your Honor.
The bottom half of page 2, your office might want to step on the gas on that because he's got a hearing scheduled in front of me on April 6th. If y'all come in
Last
asking
case
for a
on
reset
Thursday?
based on the bottom half of
Let me
page
see what I can do. Give me a
2
second.
of the detention hearing report on the 6th, I'm going to be inclined to say no and force you to go on the petition that you've got.
Yes, Your Honor. I'll let Mr. Wynn know.
So let's step on the gas. If y'all plan on doing something on that, let's get it done so we can wrap everything up on the 6th. Demarian's been back in detention for 141 days.
Yes, Your Honor.
I think it's time that the state
141
either be put
days.
to its burden of proof or there be a plea agreement and we let Demarian progress on.
You
All
said
right, that'll be the
Thursday.
order of the court. Thank you.
Okay, let me
Thank you,
see.
Your Honor.
It's kind of a long one.
Preston,
Mikey, reach back and pull boat without looking. It's a long way back.
are you Preston?
Yeah, that's me.
That
Pardon?
I don't know what that shows, but there you go.
That's me.
Just for
sir.
you, Ed.
Thank you, sir. Preston, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You
Greetings.
have the right to remain silent. You also have the right to an attorney, and your attorney, Julie Jacobson, is here. Good morning, Ms. Jacobson. How are you?
Good morning, Your Honor. How are you?
Better than I deserve. All right.
Yes.
You've been level 1-0 almost a month. However, the last court setting on the 16th
Seen this kid
failed
before.
to appear. And when you fail to show up for court when you're supposed to, it makes me wonder that if I release you again, you wouldn't show up for court the next time. You've got another court setting coming up in
I don't know why you're not
couple
getting no
weeks.
sound, James.
And
That's
so out
not
of
good.
abundance of caution to make sure you show up for court when you are supposed to, I'm going to keep you here for now. However, the fact that you're level 1-0 and you've maintained level 1-0 for so long is a circumstance I will take into consideration at your hearing. Okay, so you want to keep that. All right, thank you, sir. Thank you, Ms. Jacobson. Ashton.
Nobody out. Nobody getting out.
Are you Ashton?
Yes, sir.
Ashton, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge. Well, actually, this is not your initial detention. This is your initial detention. The purpose of this hearing is not a trial. Instead, the purpose of this hearing is to determine whether or not probable cause exists to believe that you may have engaged in delinquent conduct.
They're like
In
running away
making that
from the camera.
determination, the law allows me to consider hearsay evidence in the form of a
Psycho nut.
police
Good to
report
see you.
forwarded to me by the Juvenile Probation Department.
We're in court.
If I find that probable cause exists, I will thereafter proceed to a secondary determination of whether or not you should be ordered to remain in detention or be released to a parent or guardian. At this hearing, you have the right to remain silent. You also have the right to an attorney, and your attorney, Edwin Youngblood, is here. Good morning, Mr. Youngblood. How are you?
Morning, Judge. I'm fine. And you?
Doing well. Thank you, sir. According to the
My man.
not the yeah, we're off. Okay, give me just a second, Ashton.
We're gonna let you go on technicality. You can't find your stuff.
Packet and see if it's attached to the previous packet.
That was a phone book, by the way. Our local phone book is the size of a magazine. It's the size of a Rolling Stone magazine. Oh, he's gonna get mad in a minute. He can't find nothing.
Here we go.
This is boring as fuck. Oh, I'm sorry.
Give me just a
As
second,
F.
Ashton. Sorry.
Sorry, second.
Paperwork was a little out of order. Okay,
Many apologies.
Ashton, according to the police report, back on November 22nd of 2021, 17-year-old Ashton was referred out of custody by the Mansfield ISD Police Department for the offense of theft of property valued at greater than $2,500 but less than $30,000. According to the police report on the 5th of November at approximately 2:30 in the afternoon, officers assigned to a specific high school were contacted by the front reception desk and asked to go to bus number 356. The complainant stated that suspects, including you and two other kids, took without the victim's permission $10,000 in U.S. currency that had been in the complainant's possession. All suspects were identified as students at a high school. The complainant stated he removed $10,000 in $100 increments without his mother's permission from their residence. The complainant took the currency to school and informed several unknown suspects that he was in possession of the currency.
Oh, you
Approximately 2 o'clock
dumbass.
in the afternoon, the complainant walked out of his classroom and went to the boys' second floor restroom. On his way to the restroom, suspects followed the complainant into the restroom. One of your companions, Ashton, asked the complainant if he could see the currency and take a photo with it. The complainant agreed and removed all of the currency from his pocket and gave the currency to the correspondent to take a photo. While holding the currency and fanning out the $100 bills, that correspondent dropped the currency on the floor. Sometime before that moment, a third correspondent had entered the restroom and also observed the currency on the floor. The suspects and the complainant tried to pick up the currency on the floor. All suspects then walked out of the restroom with the complainant following behind. The complainant stated that he followed you, Ashton, out of the restroom and asked for the money back, but you refused to give the money back and walked off. Officers contacted the complainant's mother. He stated the complainant did not have permission to remove the $10,000 of currency from her home. The complainant's mother
Damn.
filed a report with the Grand Prairie Police Department. Officers recovered $500 and $100 bills from one of the co-respondents and released the money to the complainant's sister. Then, shortly before 10 o'clock that
A
same
kid
evening,
taking
one of the
$10,000
officers
to
went to the
school.
listed home for you, Ashton. You refused to let your mother come to the door. You stated that you did not have the money, and you refused to talk with the officers. Officers contacted your mother anyway on the phone and advised her to contact the Grand Prairie Police Department regarding the theft. Officers observed video footage revealing the complainant attempting to stop you, Ashton, from leaving the boys' restroom with the money in your hand, and observed you push the complainant out of the way. At one point, you can be seen fanning out money and then counting the money on the school cameras while the complainant was beside you, asking for the money back. Officers also observed the complainant attempting to keep Ashton from exiting.
So he robbed
the
a guy who stole
school,
money.
Then observed them both exit the building.
Wow.
The complainant estimates you had about $9,000 in your possession, Ashton.
Woo!
On the 10th of November, one of the officers spoke with one of your co-respondents regarding the incident, and that co-respondent verbally told the officers he was present in the restroom and that you, Ashton, were the person that had all of the currency. On the 1st of March, you were brought to JPD
A
from
shady
the Tarrant
one.
County Jail, and you received 2 years deferred for an adult case. All right, I'm going to find the probable cause exists to believe that you may have engaged in delinquent conduct. Mr. Youngblood, your thoughts?
I understand sadly that he's now on level 3. Had been doing better.
You are correct,
Level
Mr.
3.
Youngblood. Ashton, unless you are level 1-0, I cannot consider you for release.
Yep. And
And so
grabbed
on
it
that
up.
basis, I must order that you continue to be detained. We will continue to watch your behavior while you're in the back, and Judge Kim will ultimately take that into account. Thank you, sir.
I got a question.
Uh-oh.
When is,
Go ahead.
So I thought I had court on the 22nd. What was this date like?
This was a detention hearing.
But I just had one I just had one Wednesday.
Yes, sir, he did. That his parent wasn't there, and Mr. Nava gave me information. I used the information to call his parent, and I had thought that his parent would show up. At that time, he was level 1, and the court was inclined to let him go if a parent appeared, and that's why it was rescheduled.
Does that
And
answer
did the
your
parent
question,
appear?
Ashton?
Yes, sir. So
No.
I got court on the 22nd again, right?
Let me double check.
Asking all these hard
The
questions.
court coordinator is telling me it is scheduled for April 1st.
Yeah. Nate,
All
I
right,
wish I
thank you,
knew,
sir.
man.
May I be excused, Your Honor?
Yes, sir.
They
Thank
all
you, Mr.
gone
Youngblood.
crazy.
Yes, sir. Have a good weekend.
You as well. All right, are you Kaylee?
Yes, sir.
Kaylee, my name is Judge Porter. The law says when you're brought into detention,
Kaylee looks
you must
12.
see a judge within 2 business days. The purpose of this hearing is not a trial. Instead, the purpose of today's hearing is to determine whether or not probable cause exists to believe that you may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence
Every 10
in the form
business
of a
days.
police report forwarded to me by the Juvenile Probation Department. If I find that probable cause exists, I will thereafter proceed to a secondary determination of whether or not you should be ordered to remain in detention or be released to a parent or guardian. At this hearing, you have the right to remain silent. You also have the right to an attorney, and your attorney, Brian Newman, is here. Good morning, Mr. Newman. How are you?
Morning, Judge. Doing fine.
All right, Kaylee, according to the police report, let's see. 2 days ago, you were referred in custody by the Fort Worth Police Department for the offense of assault causing bodily injury with family violence. According to the police report, officers were dispatched to your home on a domestic disturbance call. Your mom reported that she attempted to take your cell phone away as a form of punishment. Mom reported that you got upset and kicked mom in the stomach multiple times, causing pain. Mom also reported that you struck her in the upper chest area, causing pain, and officers observed a visible bruise. You were then detained and transported to JPD.
Mom's got it going on up
All right,
there.
I will find that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention. Are you mom and dad?
Yes.
Okay, what's going on with Kaylee as far as the violence between mom and Kaylee?
I think it was just that he didn't get his way and got mad, and we give him a lot of leeway. There are consequences, not punishments, and the consequence was something that made him feel uncomfortable, and he got mad.
Hey, Billy. We're in FPOD, right?
Do you think this kind of behavior is going to continue going forward?
I'm not sure. That is up to Kaylee. However, the plan is to have them go straight from here, if they're released today, to UBH, and that will be addressed. So
They who?
that's where we're at right now.
All right. You know Kaylee better than anybody else.
Was it?
Do you feel safe for me to release Kaylee to you, and then for you as the parent to direct any necessary treatment or doctor's appointments and things like that going forward?
Yes, because Kaylee's going directly to an inpatient program after this. I do feel comfortable with Kaylee being released today. If Kaylee was to come home, I would not feel comfortable, but we have something set up.
No, this is a girl. This is
Mr.
FPOD.
Brawl, am I correct? Kaylee has no prior referrals to the department?
You are correct, Your Honor.
All right. Based on the absence of any prior history of
all right.
referrals to the department, based on the parent's plan of a specific course of action to treat what
Yes, she
seems
is.
to be the child's needs, I'm going to authorize Kaylee's release to the parents today. Kaylee, I hope this was a wake-up call. If it wasn't, mom and dad, feel free to get in touch with Mr. Kroll, and we can have an out-of-custody detention hearing, at which time I can consider
Hey,
whether or not Kaylee is a sufficient danger to either y'all or to Kaylee, sufficient to warrant Kaylee's being ordered into detention. So know that
Gotcha.
that possibility is there.
I was
Hopefully
very
Kaylee
confused for a
will be
second.
receptive to your direction, mom and dad. All right, that'll be the order of the court. Thank you.
Thank you, sir.
Thank you.
That's the first time I ran into that here. So
Caesar.
that's a learning curve there, people. So they didn't get out.
All right, are you Caesar?
Yes, Your Honor.
Caesar, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. You have the right to remain silent. You also have the right to an attorney. And your attorney, Larry Beaver, could not be here today. He actually left for vacation yesterday, but I'm going to
He
ask
said, "F
Brian
you,
Newman,
bud. I'm outta
another
here."
attorney who regularly represents kids in our court, to step in for Mr. Beaver. Good morning, Mr. Newman. How are you?
Morning, Judge. Doing fine. How about yourself?
I'm
Better
getting
than
woke
I
as hell.
deserve.
Don't you worry
All right,
about me.
Caesar, you have the right to remain silent. The purpose of this hearing, as you know, it's not a trial, it's a detention hearing to determine if probable cause exists to believe that you may have engaged in delinquent conduct. Judge Terry put you
Well,
on
I'm sure he is
probation.
loving it in the FPOD then.
No, I was the one. I thought I recognized you. I was the one who put you on probation last fall. You got a modification hearing coming up with Judge Terry, though. So
Mom's was right in there, though. She
yesterday,
was-
around 1:30 in the afternoon, we got a master tamper alert for you allegedly cutting off your EM. We issued the DTA, and you returned home later and was picked up at your home and brought to Kimbo without incident.
Makes sense.
All right. Well, Caesar, If you wanna
Caesar,
cut off your
Caesar,
monitor,
Caesar.
that means I can't trust you. I don't know where you are. That means you may be getting into trouble somewhere.
Keep them there, right?
Worst case scenario, you're walking down the road, you don't have your monitor on, there's a drive-by, somebody shoots you, you're lying in a ditch somewhere, we can't find you. Parents don't know where you are. I can't have that on my conscience. That was your decision to cut off your monitor. See, if you hadn't cut off your monitor, at least we would have known where you were.
I love Judge Porter's sarcasm. Fantastic.
I thought I saw Ms. Zamora earlier.
Yes, Your Honor, I'm here.
There you are. Was he drug tested when he came in?
Yes, he was, Your Honor.
What were the results?
Positive for marijuana.
Oh, now we know where he went. Does he have a
He went
parent or
to the
guardian here
drugs.
today?
Obviously not.
No, Your Honor, they couldn't make it and they were having technical issues.
Okay.
Far too busy.
Well, Caesar, you're destroying government property by cutting off your monitor, going out and getting the devil's lettuce. I can't trust you.
Bug, good to see you. The
I'm gonna keep you
devil's
here.
lettuce rears its ugly head
We'll see
again.
how long it takes for you to regain my trust. But I imagine it'll be a little while. Thank you, sir. Thank you, Ms. Zamora.
He
Thank you,
had
Mr.
every
Newman.
chance. He let him know.
Thank you, Your Honor.
Michaela.
From Kayla
My
to
name is Judge
Michaela.
Porter. The law says when you're brought into detention, you must see a
Or
judge
Kaylee,
within 2 business days. The purpose of this hearing is not a trial. Instead, the purpose of this hearing is to determine whether or not probable cause exists to believe that you may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence. in the
Michael
form of a
Malloy,
police
everybody,
report
had
forwarded
me
to by the
laughing
Juvenile
so
Probation
hard
Department. If I find
last
that
night on
probable
his
cause
show.
exists,
I
will
mean,
thereafter
belly laughing.
proceed to a secondary
More
determination
phone
of
calls,
whether or not
Mike.
you should be
More
ordered to
phone
remain in
calls.
detention or be released to a parent or guardian. At this hearing, you have the right to remain silent. You also have the right to an attorney, and your attorney, Candace Taylor, could not be here today, but
It's a
I'm
good
going
one,
to ask
Ghost.
another attorney, Brian Newman, who regularly represents kids in our court, to fill in for Ms. Taylor at this hearing. Good morning, Mr. Newman. How are you?
Morning, Judge. Doing okay.
All right. Michaela, according to the police report, Thursday of last week, you had an argument with your mother, your probation officer, and your reach therapist both visited with
The
you, and
jazz
shortly after
couch.
the therapist left, then you left home without
Schuster, the
permission.
rooster.
You later called your
Song, my man.
therapist, stating that you didn't feel safe at home and you didn't know where to go.
This is a good one.
The therapist and the probation officer asked you to go to a nearby youth shelter. And on Monday, your probation officer confirmed that you were not at the shelter to which you were directed. Mother was able to track your location to a home in South Fort Worth and contacted law enforcement to let them know where you were at.
Go
and that
take
you
care
had
of
an
it.
active DTA. Fort Worth PD was able to make contact with you, and you were taken into custody without incident. You're currently on probation. Wait, no, you're not. She's no longer on probation. Is that correct? Is Miss Elise? Yes, Miss Elise. She's
That was
on
so
probation
funny.
now.
No, she's still on probation. Her probation.
Hey there.
Next month.
Oh, okay.
Looking good. I'm gonna pull a Michael Malloy and say, everybody go and subscribe right now to the Michael Malloy Show. He's a great guy, a fun dude, and always entertaining.
Okay. Does she have a parent or guardian here today?
She does not, sir.
Okay.
Of course not.
Michaela, I'm going to keep you here for right now, just because I want to know where you are and I want to know you're safe, and we can keep you safe here. Miss Elise,
She probably
and your
appreciates
mom
that a
are
little bit, to
working
be honest
on
with you.
a plan to find you respite care. And so once they get that plan in place, then we'll take that up. Does that make sense?
Yes, sir.
Okay. You okay with that?
Yes, sir.
Sounds like a good plan?
Yes, sir.
All right. All right. Then that's what we'll do. Miss Elise, continue to work with mom and
I'm
keep
telling you,
Michaela
the phone
updated
calls
on
are
the
your
progress
wheelhouse,
that you will.
man.
Thank you, everybody. Thank you, Mr. Newman.
Thank you, Judge.
Summer's-
Thank you.
Have you ever ate a Cheesecake Factory? That was Michael Malloy calling
All right.
In-N-Out Burger, asking the lady
These
at work there
hearings
that.
have been broadcast live on YouTube in keeping with the spirit of the open courts provision of the Texas Constitution. However, Section 5408, subsection C of the Texas Family Code provides that when a child or children are under the age of 14, the court may close the hearings if the court.
Yeah, so they're going to see some of the kids that are too young to be on here. And with that, I'm going to wrap things up. Me and Creed will be back here in about 2 hours with the Voyeur Voyage. We're going to check out things on Spy Life. A lot of new people on there from the Ukraine that we're going to check in with, see how things are on the front there. I just want to thank everybody who took time out of their Saturday morning to drop by. We're going to try. The plan is, I guess, me and Creed are going to try and do more of these Saturday morning live magistrate things that go on. So I think that could be a lot of fun. I had a lot of fun over there last night, Michael. You did a great job, man. Home run. So yeah, I'm going to zip on out of here. I'm going to say au revoir, sayonara, arrivederci, cheers, whatever your choice of room exiting exclamation is, your choice to pick yours. We'll say out of here. We'll see you very soon. Yeah. And until next time, please remember. Good job, Mikey. I like your show, even if you do talk over stupid.